Buongiorno a tutti, buon venerdì. Siamo gli ultimi di questa settimana estremamente ricca e interessante. Solo una indicazione tecnica, perché è giusto che sia così, è giusto, se no c'è il rimbombo. Vado avanti a parlare per essere sicuro. Adesso è finito, eccoci qua. Grazie, solo un'informazione tecnica in italiano perché poi ci spostiamo sull'inglese, solo per dirvi che alle 4 dovremmo lasciare la sala per motivi organizzativi tecnici, in sostanza devono riportare la nostra biblioteca a quello che è di solito. Thank you everyone for coming here. It's Friday afternoon, I know, but sometimes it happens that some of the most interesting issues are coming at the very end. So this is what we call in Italy ciliegina sulla torta, no? The cherry on the cake. So we have the possibility now with Professor Goodenough to talk about some interesting issues, particularly from, as far as I understood, from a practical approach. Some theory, nobody forgot the theory of all the week, but after some theory, I think that some practical issues will also be addressed by Professor Goodenough. I want to thank you very much for coming here. Thank you, Dr. Santosuoso, for helping in organizing this event and all the support you usually give to our bar for these issues. I'm very much happy to discuss and to listen to what Professor Goodenough will tell us, because I understand he also will touch something about insurance contracts. So the topic you know is AI applied to contracts, and also in particular insurance contracts. As an insurance lawyer, I'm very much curious to learn something today, because insurance contracts, you know, are contracts where people hope to predict the future, hope to minimize the risk of all our lives, which is, I think, almost impossible. But nevertheless, I think that also from another perspective, not only what we use every day, the contractual issues and the economical issues, also from Professor Goodenough's standpoint, I think we will have something to learn. Just something I wish to ask you as from the beginning. Throughout this week, we organized this week for one purpose. Everybody talks about artificial intelligence, predictive intelligence, and so on. This is on the mouth of everyone. Learned people, simple people, experts, not experts. The point is that we decided to organize this particularly because we want to be ready for what will happen tomorrow, for what is happening today, as lawyers, meaning we have a social role as lawyers. We are the link between judiciary and the people, the citizens, and we want to exploit all we can do with all our means, with all the means we have in our hands, because our reason for existing is protecting the rights of the people. So, keeping this in mind, I would be happy if along your speech, you will also be able to tell us something on how to still be lawyers in applying artificial intelligence also in the contractual field. So, thank you for your speech. Amedeo, if you want to tell something and introduce our guest better.
Yes, thank you. 9 years ago, Professor Goodenough and me edited a book whose title was The Challenge of Legal Innovation. And Professor Goodenough was already a pioneer of legal innovation in the United States, okay? And I remember one day he told me, Amedeo, don't consider that the things are already done. Huh? Even in the United States, the innovation, technological innovation in law is something that is starting just now, more or less. It is not an old issue. The title is still available and has still some value, okay? We discussed the issue some days ago, and we decided that, okay, it's still good, even though there is a great difference. Great difference from 9 years ago is that now we are in the middle of this innovation. The innovation is not anymore an esoteric issue for people that are fan of technology and so on. It's something that is in our lives. So this is the moment to shift from the if to the how, okay? And so one point that we can discuss later after the Professor Goodenough presentation is, okay, what is the meaning of working as a lawyer, but also as a judge, as a practitioner of law, having the help of technologies like generative AI and things like this. This is available. If you need to summarize a brief of a colleague of yours that are on the other side of the competition, of the litigation, and you have to summarize in order to develop your position, okay, but it takes a lot of time summarizing these things. If you put the part of the brief of your colleagues in ChatGPT, the free access edition, immediately you can say, please summarize this in 15 lines. You do not stop typing these words and you have already there. This is just a signal of how this is a practical issue today. And we have the opportunity to have Professor Goodenough here today because he was yesterday in the kickoff meeting of a new center, research center, that we created at the IUS Pavia, the Institute for Advanced Studies in Pavia. And Professor Goodenough, with also other people from Stanford University, like Roland Bergel, Margaret Hagan, are members of the advisory board. We have a cooperation agreement in progress. And we asked today Professor Goodenough to give preliminary an overview of technology applied to law in practical terms, and then to focus on the experiment you are performing at Stanford University, especially in Codex. Okay. Oliver, you have the floor.
Thank you very much. Thank you very much for having me here. Thank you very much for coming. It is Friday afternoon. Oh my goodness, so you are brave to be here. I appreciate it. Thank you very much for letting me speak English. I apologize, I do not speak Italian, but I know that you are all multilingual and we'll manage with that. I appreciate it. I'm going to give a talk today, as was said. I have some slides prepared. I will hopefully I will be fast enough that we can have time for further discussion, further questions from people as we go forward. Let me get this actually changed over in view. Actually, slideshow. There we go. Beginning. That's shifted over. Not yet. Hang on. There we go. Okay. All right. We will have the whole screen here. I will do that. Is that no? Okay. We will make do. All right. What I'm going to talk about today is computable contracts in particular, but also practicing law in the AI era. And when I say AI era, as we were saying, it will not change everything, but it will change many things. And AI is going to be something that we have to understand and incorporate into our work as lawyers, as judges, as people in the law. I'm going to suggest a few approaches to that, but I'm also going to take you a little bit deep into the contract piece as well. So first of all, let me tell you that, remind you, this is an American perspective. I understand that it is not necessarily going to always match your experience here in Italy and in the EU. Thank you again for letting me speak English. Our legal systems, although it is often said they are quite different. They're actually not that different in many ways. We have similar traditions. We have similar traditions of judicial review, of the role of law. Your statements about what we do resonate. We I think, have a significant degree of overlap. But perhaps in America, we may be a little more open to change, although that's maybe a controversial statement because the bar in America is also fairly conservative. We are good at what we have done for years. We are proud of being good at what we have done for years. We're a little scared that we might have to do something else. All right, so it is openness to change, but concern. Let me also give you my own perspectives and disclosure. I am actually, in addition to being a professor, I am involved with a company that uses AI as a basis for, actually, we do creating investment portfolio for investors on an investment advisory basis. So I have some interest in the fact that AI is available, but it is not in the law. It is in the financial world at this point. The topics I'm going to touch, what is AI? A little bit on that. Many of you will know some of this, but it's worth reminding ourselves what AI is and does. We're going to look at machine learning approaches to law. We're going to go first with rule approaches to law, and then we'll look at machine learning approaches to law and explore them a bit as well. And then finally talk about the challenges of making some of this transition as practicing lawyers. So what is AI? What is AI? AI is a term that has come to focus in particularly on machine learning, but it is not just machine learning. AI originated in Dartmouth College, where actually I'm also a lecturer. It was originally viewed more on rules than on learning. And there's this branch that's called rules-based AI, which is where we use our knowledge as humans and other knowledge to construct a system of rules, setting out a determined process, a process that is fully laid out in the rules of the software. Traditional law is moving in this direction. Greater specification, again, in traditional law, we are already seeing that we are moving to more rules, perhaps in the US, less the common law case tradition. We are more and more elaborating rules and regulations and making them clear and apparent. We set them out in code, in the civil code, in language. We'll set them out in code in computer programming. These are both ways to do this. We'll explore that in a moment. The other main branch of AI is what's called machine learning. And this is what we are now often referring to as AI, but it is one branch of AI. And in machine learning, it is so interesting. Machine learning, basically we have big machines that we let try things out over time. And what is often through what's sometimes called an evolutionary algorithm, they are self-correcting over time. They ask themselves, was this a little better than the last time? Oh, okay, I'm getting better. Is this a little better than last time? And they train themselves up on some kind of corpus of material and then are able to do things with that. The first big thing that they have done is find patterns and make some predictions. Find patterns and make some predictions. And this has been actually involved in law for some time, finding patterns and making predictions in e-discovery, which is, I understand, more in America than in the US, but than in Italy. But it is where we have these stacks of things from the other side gives us on all their emails in a court case, and we've got 10,000 emails. How are we going to read them all? We don't read them all. We train the machine a little bit for what we're looking for, and then the machine reads them all. This has been happening for 10 years. That's a form of pattern recognition, information discovery, using the AI to train it up to this is the pattern we're looking for, find this pattern, and it goes and does that. The work I'm doing in my company is along that line. It's pattern recognition about companies and that kind of thing. The big revolution that we've seen in the last year and a year and a half, and it's really been in the last year and a half or so, is the letting loose of these LLMs, the large language models, also known as generative AI, because now the AI not only recognizes the patterns, but it generates something from them. Okay, so the older AI just found the patterns and put it to use. the new AI finds the patterns and then generates something as well. So that's why we call it generative AI, is because it's creating something from its recognition of patterns and all. The thing to remember in all of this is that these are probabilistic. They are not determined. As I said, the rule-based is determined. If it is X, then we do Y. If it is not X, we do Z, and that is built into the program. These are, well, I don't know whether it's X or Y, but I think it's probably X, and if it's probably X, then we probably do that. So it's and so you have to remember that these models are not deterministic in the same way, and that's an important lesson in their application, as we'll see when we get there, because you cannot fully rely on them yet, because they are this probabilistic piece. So it's also important to remember what they are optimized for. What has this one been optimized for? And most of the large language models have been optimized to produce a coherent language response to a prompt. They have not been optimized for search. Yes, they can do some search, but they're not optimized for that. They're not search engines. Google is optimized for search. ChatGPT is optimized to tell you something coherent. So they are not optimized to be accurate. They're not optimized for truth. They are not optimized for completeness in any way. They are just optimized to give you a coherent response. And that is why they suffer from these hallucinations and things like that. They're not omni-capable. They do that. Now, the AI that I use in my company has been optimized to find certain things out about companies. It cannot tell you, it will not write a poem. ChatGPT will write a poem. It'll write a bad poem, but it will write a poem if you ask it. But my AI will not do that. But instead, it will tell you something about a company. So it is always important to remember what the AI has been optimized for. And we get used to the fact that we think these large language models are magic, because you ask it a question and a coherent answer comes out. Cool. The coherent answer is not necessarily correct. In fact, it may well be wrong, okay? Because that's not what it's been optimized for. All right, so those are the two branches of AI, and I think it's worth keeping that in mind. I'm going to explore both of them. But first of all, though, we're going to explore a bit the rules-based approach. To elaborate a little further, in a rules-based approach applied to law, what we are typically doing is seeking to do a direct representation of the rules into computer code. Okay? And we're going to directly represent these rules into computer code. Classic examples of these that have been around for some time are what's sometimes called expert systems. I don't know whether any of you use a tax preparation software. I do. If you use a tax preparation software, then the tax code has been put into the software, the rules of the tax code, in an expert way. They've been translated in, they've been hard-coded. There's nothing probabilistic. It's not saying, oh, I think maybe, this is a deduction. They say, no, here, if you put it here, it's a deduction, and the arithmetic is all hard-coded. It is not probabilistic at all. Government interfaces are often this way now. Again, in the United States, if I deal with the tax people, it is through an interface. I do not speak to anybody anymore in government. It's all through some interface. And that interface is then representing the regulation or the form or whatever it is. And that is, again, hard-coded in a way that is rules-based through that kind of expert system approach. Now, sometimes people say, oh, but then there's no human judgment. And that's not fully true, because we can have the human judgment button, or something a little more sophisticated than that. But we can say, oh, if there is a problem with fairness or with good faith, or one of these human conceptions, these things that humans think about, we can ask the expert. We can ask the judge. We can ask the human in the robe, who is this good faith or not? That is essentially what we do in the regulations anyway. If they're in words, is the regulation is there, and if we push the ask the judge button, we go and ask the judge. We can build the similar kind of step into our software. The fact that it's in software does not mean it's all robo. It means that the steps have been laid out clearly in some kind of computer code instead of in text. That's really what it means. So we can keep that there. Now, it is hard work to produce these things, because you have to get the experts, you have to sit with I don't know if any of you have been involved in these kind of computerization projects. They're hard. They take time, they take some money, and when you are done, if you've done it right, you've got something that's quite useful. because you can now have all the benefits of automation, of speed, of scalability, of all those benefits that we're going to see a little bit. But you have to pay some cost to get there. If you are a consumer, when it's been done, if it's been done well and it has a good interface, now you are a happy person because somebody else did all that hard work. Now I just I sit there and use it, although perhaps they charge me money, so maybe it's not so wonderful. An example of this that I've been working on, which is the one that's been mentioned, is this computable contracting project at Stanford. And here what we've taken is basically a contract, an insurance, and have done this automation step with it. This is exactly this thing I've described of sitting there with some time and money and some experts in computer science. We have done that with the insurance contracts. By the way, on contracts, one of the things I think of them as a blueprint for an expected transaction. Okay, first step. Second step is protecting the bargain in some way with things like representations, warranties, and covenants, etc. And then a switch yard to a new blueprint on default. If there's a default, then we have a switch yard to the new blueprint. So, this is the hard part. This is the hard step. This is where he said, "Oh my goodness gracious, I fell asleep when I was." Law is computation. Huh? What does that mean? Computation is a way of conceptualizing stepwise rule-governed processes. If it's a step and it's rules, it's a computation. So classic computation, if X, then Y, if not X, then Z. That's a little step. Sounds familiar? That's the kind of thing we do in the law all the time, right? We have that code in the law. And this goes back to Larry Lessig's code is law piece. Well, we can flip that over and say law is code in a very, very real way. Why? Because even in natural language, in English, we have legalese. In Italian, I suspect you have the equivalent, this kind of convoluted lawyer language. Why do we use that? Because we are bending language to make it into a computer programming possibility, not computer, human programming. We are converting it into a very precise, stepwise, definitional statement. So we could have Java, instead we have English. All right, it is a way of doing this in a hopefully clear, stepwise fashion. By the way, this is not just for language and things. The periodic table is a computation. There's nothing between hydrogen and helium. It is one step, next step. Actually, so computational chemistry is very popular these days. Why? Because it fits nicely. Biology, the DNA structure has 4 elements in it, and they are stepwise, and they are linked together in the DNA chain. That is all a computational statement. The alphabet is a computational statement. We have distilled down sounds into 26 or 7 or whatever it is letters, and then we use them to break it up and make it discrete, make it stepwise in that way. So all of these are examples in other fields in nature of these computational steps. The law, I will assert to you, this is my little jurisprudence. The law is essentially an exercise in taking the continuum of life and the feelings we have about what's right and wrong, and instead converting them to these computational statements, converting those feelings into an if this, then that set of rules. Okay. Is it wrong to kill somebody? Well, oh, it's wrong, it's terrible. Well, in the law, it's wrong if there was, if it was premeditated, if it was angry, all the things which are the different elements in that. We have taken that smear and we have made it into elements. And when we do that, we have created a computational statement in natural language. So one of the reasons why it's interesting here is that law can be specified in machine-readable computation. Why? Because it is already computation. The step the classic legal step, I would argue, is a step towards creating a computational statement to begin with. Whew. Okay, that's hard point number 1. What is computation, and does it map to law? And I hope that I've at least got you intrigued that both might be true. If a contract is, law is a computation statement, a contract really is that as well. And one of the nice things about this is that there's something in computation theory, there's something called the translation property, which is if you have specified a computation in one formalism, you can also specify it in other formalisms typically. And what we've done with this is some years ago with a colleague, Mark Flood and I, we took a simple loan agreement and then specified it into what's called a deterministic finite automata. There we go. You don't need to remember that, but it is basically a format for specifying computational things. Here's our simplified loan agreement. There's the loan, the repayment path, all of that, and then all of these other things which are the unhappy path. The happy path is what happens if we pay everything. Then there's the default and the acceleration and all the things that go into standard loan agreements. And this is a representation of that agreement. This chain of events is the logic of that agreement as broken out into this deterministic finite automata. The green is the happy path, that's everybody repays. The others are defaults. What happens if there's a default? Okay, there are 4 different conditions of possible default, or 3, and then a non-payment. And if there's a problem with those, then we have a right to cure, which sends it back up. And if not, we have come down into an acceleration and a proceeding that is all the things that go wrong when you're a borrower and you didn't pay. Okay. That whole branch over there can be then represented in this computational way. The steps of that can be represented in this fashion. Now, that was a loan agreement. At Stanford, we've been tackling these insurance agreements, and it's made interesting and relatively easy because there are really only 5 or 6 different pieces that an insurance agreement does. The structure of the insurance bargain can be broken out in this. Now, the details of that bargain can be very separate and different and complicated. The actual structure of the insurance bargain is these 5 or 6 elements. First element is the policy in effect. If it's not in effect, go away. Second element, are there conditions for keeping it in effect? And if so, have they been met? And in the one we're going to look at in a moment, you're supposed to have a doctor's visit. Did you have the doctor's visit? If so, check that box. If not, well, that's a problem. Then come the coverage triggers. And the coverage triggers are the things which are the core of this, which is, did you have an accident? Did the car get hurt? In this case, did you have a sick, or were you sick or injured? Did you spend a night in a hospital? This is going to be a hospitalization policy. If you spend the night in the hospital, you get $1,000 because that's what the deal is. That's the insurance. This is what's called a hospital coverage policy, where they don't look to the cost of the hospital. They just give you some extra supplemental money if you meet the requirements. Next one is exclusions, and many insurance have exclusions, and the exclusions are where you say, were you drunk when you drove? If you were drinking, we don't insure your car. In this case, were you too old? Were you skydiving? Various dangerous things. What might be that? These are exclusions. They negate the coverage. Okay. Finally, there's a benefit calculation. There's a benefit calculation, which is just arithmetic. If you qualify for a benefit, how much are you going to get? What is the deductible? Have you had prior claims? All that kind of thing. And then finally, process management, legal background. Is it the laws of Italy? Is it the laws of France? What governs? That classic stuff. So those elements are effectively what we see in an insurance bargain. And that helps us because then we can design a representation of that into code that then allows us to automate that process. There's the natural language version of this policy, by the way. That is based on a real policy from the Chubb group that we've simplified a bit. This is what happens when we automate it. What's this? Well, on the right-hand side, in the computable contract field, there is a way of expressing these things into code. And it's what's called logic programming. Basically, you specify all of the possible events that matter, and then you say, where do they fit into the logic? Are they things which you have to have, in which case the answer has to be yes, or are they things that you're not allowed to have, like the exclusions, in which case the answer has to be no. And we set it up this way, and then we have a kind of program, a logic program. It's called a prologue or epilogue that sits on top of this. And when it sits on top of this, that requires us then to, on this other column on the left, to have an interface where we can toggle things in and out. We can check the box. Is there an age limit? Is it 65, 75? What's the age limit? Is there, are we going to have the exclusions for skydiving and military service, et cetera? And if I had this hooked up to the demo, if I toggled one in or out, you'd see it disappear in the traditional contract and then disappear across in the computable specification. Why? Because this allows us to do this kind of automated formation for the contract. That's pretty cool. What is even cooler is that once you've done this, then we can have a claim analysis. We can automate the claim analysis because now we can put in a different program on top of this and say, are the elements of the claim all there? Remember, the elements of the claim had to be, it was overnight in a hospital when we didn't have the exclusions and it wasn't, or the conditions had been met. All of those things can then be done, and we can then ask the facts that have been submitted, does it match a claim or not? And so again, this then will simplify the claim adjusters' task significantly because the answers will come in and it will be there and available for them. Now, we probably want to have an override built into the system for some reason. If there's a reason to have a human go, no, that's not quite right. But in most cases, we discover that this kind of thing is very helpful to the adjusters. Why do I say in most cases? Why? Because the AXA company, which has helped to support this research, the AXA insurance company out of France, has implemented similar things in several policy groups in countries across Europe. And so they have experience with this, and they find that they are saving, they think 2 or 3%, 4% in adjuster time and claim, which is a significant amount of money overall. So tens of millions of dollars are being saved a year, they're estimating now already with just what they're doing. So we see then that we have this kind of ability to have a computational contract, computable contract, to express the contract in terms that the machine can understand and help us create and help us implement. And in addition to that, then there's a whole layer of analytics that can go on top of this. Risk analysis, what's our exposure? Instead of having to read a bunch of contracts, they can go push a button and say, what of these is covered by skydiving? What's our skydiving risk? And they would go, oh, okay, it's not very much here because we've excluded most of it. What's our hurricane risk? Oh, well, with different policies, but they can ask those hurricane-related questions to their database and find out. Regulators can query this to get information on coverage. Consumers can query this and say, oh, am I covered? Oh, I'm not covered. Why am I buying this insurance? I don't, this wouldn't cover me in these things. So there's consumer-facing benefits, there's company-facing benefits, there's regulatory-facing benefits, there's a number of different benefits that come here. So how do I do this in my practice? Well, one of the things you can be is a knowledge engineer. If you are in the insurance field, the insurance people need knowledgeable insurance lawyers to come in and work with their computer people to do this. And most of this is stuff that is not going to be seen by a lawyer very much anyway, right? This is the kind of contract that once it's been done, how many of us go to say, by the way, I should talk to my lawyer about my insurance contract. We just kind of take it for granted and go forward. Fancier contracts we could do this with, but that may or may not be the right thing to do for complicated license agreements, merger and acquisition agreements, more complicated agreements we could do it, but may not be worth it. But certainly for these consumer-facing contracts, very worthwhile. All right. So we see then this rules-based approach. We have a demonstration from this. We can imagine it also in things like a tax law, et cetera. This is already with us. And it is emerging faster and further. And one of the tricks is to figure out how to do it better, which is hopefully what we're doing at Stanford, and how to go forward with that. Machine learning approaches, how do we apply that to law? Am I okay on time? I'm all right. Okay. E-discovery, I've mentioned that. That's this American thing where we find the patterns. Research of various kinds. Various kinds of research have been done with. We ask AI to do research. Again, a little complicated because AI research, if you ask ChatGPT, it will give you an answer. It will be wrong because it is not optimized for research. But there are specially trained pieces by some of the major suppliers, LexisNexis, others who have done training and designed, optimized the model to be a legal research tool. Those are better. Okay. One of the tricks with this is you want to make sure that the tool you're using has been trained to do the task you're asking it to do. If you simply go on ChatGPT and tell me what are the laws in Italy that apply to privacy, it will give you a list, and the list will be wrong. Okay, quite possibly anyway, it'll be wrong because it has not been optimized to do that. Other litigation processes and analysis. There's some very interesting stuff being done on outcome prediction and risk analysis. For instance, in the US and perhaps in Italy, these insurable events, right? Insurance companies are saying, what is my risk in pursuing this case? And they feed in a whole set of database around past insurance litigation, and they analyze the factors of the case, and they make comparisons, and the machine says, the risk here is $10 million recovery. If you are the insurance company and you can settle the claim for $5 million, you think you've done well. Okay. Now, a good lawyer thinks they can do the same thing. They go, okay, I've seen these cases. This one is a $10 million case, this one $5 million. Okay, but the machine will help supplement that and give you a second opinion on exactly what that's worth. By the way, there are people now buying and selling case outcomes based on these AI. And there's a whole market in case outcomes in the United States. I don't know whether that's true in Italy as well, but people are buying and selling. I've got a litigation. Oh, we'll buy your judgment. Here's $1 million today. Take it, and we'll take the risk and carry it the rest of the way. Okay. Drafting, document management and analytics. We can turn these things loose on documents, as we've heard. We can ask them to make a summary. We can ask them to do a bunch of things how they proceed. We can do that, and we can have various analytics. We can ask it to do drafting. I gave my students an exercise where I told them it was voluntary to use AI to draft the first draft of a licensing agreement. I'd ask them to draft for me as an assignment. About 50% did, about 50% didn't. The 50% who used existing models probably mostly did better than the ones who asked the AI. Why? Because the AI wasn't all that good. They were using the chat GPTs, etc. Perfectly decent first draft, but not much better than that. Due diligence. Again, we can have it due diligence, stacks of documents and things we can have it ask questions for. A bunch of these things we can do. What's the value add in these? Increased productivity, okay? Improved outcomes for the client. If we use them correctly and intelligently, they can do that. And they are likely to push. Where the push for adoption on all of this AI is likely to come more from the clients than the lawyers. Why? Because we make money as we are, right? It's fine. Don't make me do new things. I'm okay. The client is going to come and say, hey, I understand I can save a bunch of money if you do this. And then they will tell you to do it. And then you will have to figure it out. Improve client experience. Why? Part of it is communications. We can let the AI help with our communication. It turns out that the failure to communicate with their client is the most frequent complaint with lawyers in the US. I don't know if that's the case in Italy, but in the US, they say nobody communicates. Let the AI develop an email, say, we got your phone call. Thank you so much. We are very busy right now, but we will be back to you soon. That's that kind of communication, and also understanding, help clients understand things. Concerns and cautions. Data privacy, okay, yes. And there's data privacy problems in the training. How has it been trained? Do we let it train? One of the things in my company we are discovering is that there are AI applications that will allow you to wall off your data from their training. Because what your client doesn't want is for when you turn the AI loose on your data, that suddenly your data has trained their data, and that's something you want to avoid. Accuracy, hallucinations we've talked a bit about. There are techniques to improve those results. Human curation is the final backstop, which is, a human should always look at what the AI has suggested. At least at this point, that's a good idea. There's sometimes bias in these things. They're trained on fact sets that have bias in them. They will be biased. Of course, the reason the fact sets have bias is because the humans who did them had bias too. So, but it is worth keeping in mind. Job displacement, yeah, there may be some people who don't get hired because of all of this. If it does save time and make greater efficiency, it will do that. And then there's all the regulation of AI that particularly in Europe, I understand in the next few weeks, it's about to descend upon all of AI, and we'll see where it comes out. So last topic is making the transition. There are significant barriers to entry in this. You are here, so you are game. You are ready. You are, as we say in English, you are ready to try. But it's re-education for us who are seniors. It is opportunity cost for juniors. Do I pay attention to this stuff, or do I just do the traditional development cost of applications? The first mover and network challenges. If I adopt this and nobody else does, will I get the full benefit? Well, there are solutions to some of those. One is you can make it a personal and a firm priority. I need to know this. My firm needs to know this. My associates need to know this. We will just take some time and do it. It's not cost-free, but if you do that, you can push things forward. I'm old enough that I remember the transition from dictating to my secretary and typing on the keys. And the senior partner in my firm said, "Oliver, lawyer fingers do not touch keys." Well, that lasted about 2 years, right? And then finally, everybody got a word processor on their desk. There were 2 very uncomfortable weeks while we learned how to use a word processor. And then we learned, and then it was fine. We went forward. There's the same kind of thing is going to happen here. There'll be a few intensely uncomfortable weeks where you're really frustrated and mad, and then it'll become clear, and these applications will be something we can use. Use off-the-shelf applications. You don't have to develop it yourself. Use off-the-shelf applications. There are a lot of them coming. It can also, by the way, be an opportunity. If there's a lot of venture capital being spent on AI and AI and law, there's 100 million or so in the last year in the U.S. Of venture capital funding. If you've got a project that you want to develop, maybe it'll be something you could share with all your other lawyers and make some money. So it's out there as a possibility. And then collaborate on interoperability and standards. This is the role for the Bar Association and the courts, is to come together and help this process. Say, this is how we're going to do this. We can get some of those standards together. So that's my talk. That's my formal talk. Thank you very much for your patience. It's not been a short talk, but I hope it's been useful in framing up how this works, the different flavors of AI, the rule-based AI, how it works to create things like computable contracts, how we can apply them, the machine learning style AI, what some of its strengths and weaknesses are, and the notion that in the world going forward, as we do this, it's not going to be easy, but the 21st century isn't easy. The 21st century isn't easy, and we're just going to, this is part of it not being easy, and we just have to kind of get our heads wrapped around this and do it. Thank you very much.
Thank you very much. Maybe before giving again the floor to Amadeo, may I ask if any of you has some question to put to Oliver? Good enough? Don't be shy. In 10 minutes, we're off. If this is
As a professor, you sometimes hope for a lively class, and you sometimes hope to have stupefied them and made them.
Dr. Santos, you want to?
Yes, I have a question for you. So once you have the basic scheme of an insurance contract, a computable way, yes, but we have plenty of differences in different jurisdictions on many details. There are differences in Europe in comparison with the United States, and even within the United States, there are different regulations in states. Do you think that the system you propose, with the Codex in Stanford, is flexible enough in order to be able to cover all these differences?
And the simple answer is yes. The complicated answer is that it's just about time, money, and understanding. Because each of these differences in regulatory structure or whatever are things that will be reflected either directly in the policy or can be built into the surrounds to the policy. And it is not a matter of can it, because the answer is yes. It's more an answer of how much of that will we build in as a matter of cost and attention. Now, luckily, many of those things will recur across a number of different policies, so we can build them in as a kind of a recurring layer in a policy specification platform. Some will not be, and that will add a little cost. So all of this is theoretically doable. It's just, we add different toggles and different criteria and add a few questions to our software. But as with anything, customization, it costs money and time.
Yes. And another point, let's suppose that, okay, the first step is to start from words, and to arrive to computable structure. But what you propose in your paper, there's a nice paper that Professor Goodenough published and it is available freely on the internet. You say that the best way might be to not to go through natural language, but to go straight to the code, starting from the abstract concept of
Yes.
those.
Yes.
Okay, so no, my question is not this. Okay, my question is later. Do you think that a contract with this structure and with this shape, okay, can be accepted by consumers? Because it is very, very abstract. Perhaps people are very normal people, not lawyers that are normal in another sense, but normal people are very skeptical toward the insurance companies. And once they see something that is abstract, not easy to understand.
Two things. What they are seeing already is something they don't understand. They get sent a policy, it's in a natural language, but it's in this long, twisted natural language. They do not understand it. They go, what's this? And we just kind of sign things because, well, my broker said it was okay, I must be. So already most people can't consume the current kind of specification. If we specify it directly in code, one of the cool things we can do is we can put a user interface on it. And the user interface can have a number of different tools. It can have a pie chart of things that tells us what's covered or not, what amounts. It can have a query system where we say, hey, if I go driving in Italy and I have too much to drink and I run into a tree, is my car covered? And if it, if the queries are put in the terms of the contract, which they can be guided to be done because the user interface can guide you there, you can put the actual query and it will come back and say, no, Professor Goodenough, you're not covered. Sorry. Oh, okay. Or even just things like renting a car. We've looked at this at Stanford. When you go to rent a car, you get this, do I need new insurance or not? Is my current coverage? I don't know. And this would allow you to make that query of your own insurance thing. You just log in and say, hey, insurance company, I'm renting a car. Here I am I covered? And with any luck at all, if the system has been set up to have the user interface interact with the specifications of your policy, it will give you an answer. And I would argue that that is actually much clearer for a consumer than saying, read the policy.
But if this is true, what is the interest of insurance companies to promote this kind of change?
Insurance companies do not make money off of cheating their customers. The way insurance companies make money is actually by encouraging customers to give them money, which they invest. Insurance companies make their money mostly from the investment on the reserve capital pool. It's true. And therefore, if they got more clients, if the bargain was clearly stated, they actually are fine with that to the most part. They're not, they don't want to pay what they don't have to, but also they discover that they are overpaying frequently because their adjusters aren't very good, and the adjusters make choices that mean they're overpaying. So the overpayment problem is almost as big as the underpayment benefit. So again, what we find is that insurance companies are interested in this. Also, I should mention that the adjustment cost, the administration of claims cost, is a very significant piece of the cost of the insurance company. It could be 10, 15, 20% of the insurance company's costs. They are happy if they could save half of that. They could save 10% of that. They will save millions. The big ones will save millions, tens, hundreds of millions of dollars a year. So that they are looking for saving in the cost. They're looking for making their product more attractive, and they're looking for certainty in how it comes out.
So may I just on this point put a question? So do you mean that with this contract, with this intervention of AI, we might leave back the idea of the 10 pages contract nobody of us will never read, and we will have a sort of a living contract through the machine, where you can ask the machine, I would like to have this, am I protected for this? Is this the case?
Exactly. And you see this already. Our friends at AXA have implemented some of this already. They have a nice system. We happen to think our system may be even a little nicer. They have a nice system to do this. They have developed it in-house. They are deploying it. They are already seeing the savings we're talking about. They report back to me that on an informal basis that there is significant money even in the early stages that they are saving from in administration.
So which means we might be friends of our insurance companies, which is strange for us.
Friends would be strong, but good neighbors anyway.
Yes, I can imagine that in the room there are some lawyers, litigators, okay, and it would be nice to have your opinion as a lawyer on the side of the consumer or of the insurance company. Do you think that having a contract in this technological, let's say, format would be helpful or not, would be convenient or not?
Very shy.
One question that I hear about this from litigators sometimes is, how would we prove this in court? How would we prove this in court? How would we bring this to court? And in the U.S., we have a law called UETA, the Uniform Electronic Transaction Act, which says that a contract cannot be made invalid just because it's in electronic form. So if you specify it in code, the court has to accept it, provided it's otherwise a contract. Okay, well, how would you do that? Well, two things. One is that you can just demonstrate. You ask the contract, were you paid or not? Should you be paid or not? Okay, well, we're going to dispute that, and we say that it's not correct. Well, then how do we do that? Well, the same way we get an expert in, and the expert will lead through the code, and we can demonstrate. You've seen here the code on the right-hand side. It was actually relatively clear and explainable in certain kinds of ways. So the judge will have to be educated and satisfied that is what the code said. How did the consumer know that that's what the code said? Well, the consumer knows because the consumer had the chance to try it out and see whether they felt that it worked or not. There's nothing insurmountable in it. There's some complexity, but it's not insurmountable. I don't know whether that would work in Italy. Actually, Beatrice is our expert on the enforceability in Italy.
Oh, well, we need a microphone.
And I know Beatrice is because she has collaborated with us at Stanford and has actually written a paper on the enforceability of electronic contracts in the EU. So
yeah, so I'm not a litigator. Actually, I don't do litigation. I'm a lawyer. But so right now, these kind of contracts are actually enforceable. So we have no regulation, especially on them, like in the US. And I find super interesting the fact that the US law that was mentioned is from 1999. So it's like super trailblazing for the time being. So we have no specific regulation right now on computable contracts, but maybe the question is, do we need a specific regulation on them? Because actually, computable contracts, the way I see them, they're like, using a metaphor, they're simply a contract which can be used, which can be read, understood, and executed both by a human and by a machine. So I find it really, really interesting, this point. And talking about, again, lawyers and litigators, the main objection that I get when I talk about computable contracts are we losing our jobs as lawyers, and how can we make them work with us? Maybe the question, maybe the thing is that we have to learn how to change, not to adapt to the technology and not ask the technology to adapt to us, but maybe changing and adapting to each other and create a new ecosystem, which can be powerful and benefit both us and our clients, and like working all together like this. So this is my opinion. So we are not losing our jobs. We simply need to change them, because right now most of our jobs is like litigating or using the contract as it is after it's been finalized, for example, because insurance contracts, for example, are standardized contracts right now. So maybe this is a push towards customization, which can be potential with benefits for all of us and for our clients as well. So, but please give us your opinion as well.
Thank you, Beatrice. I think we are moving towards the end of our meeting today. So, Dr. Santosuoso, if you want to say some final word, and then we are going to close.
Thank you for being here on Friday afternoon.
Oh, yeah.
And let's continue our conversation. If you want, you can get the Professor Goodenough email address and also mine, and we will be ready to interact, because I can understand that some of these points can be difficult to be metabolized, let's say. Okay. We need time for changing our mindset, and we are open. I suppose I spend also your name. Huh? We are open to any kind of further discussion.
And we can stick here for a few minutes if there are people who want to come
Outside the
in.
door.
Yeah,
because
outside the door,
of
yeah.
the- in the
So
corridor.
let me thank again. Thank you, Dr. Santos Rosso, for helping in the organization of this afternoon. Thank you, Oliver Goodenough, for being with us. Thank you to all the staff which assisted throughout the week, and particularly to you who followed us for a few days now. And now we deserve a good weekend. Thank you. Goodbye.